So, welcome everybody. It's the first CPD we've had for a little while, and I'm very pleased that we're going to be looking at consumer rights. It's something that I think is probably quite a significant part of many of the cases we do, probably in ways that even the sheriffs don't recognize. And I think there's a whole interesting set of issues around how much the law comes into. A number of people have wondered how much law has in fact got to do with simple procedure. Um, so I think it's just quite useful for us to have a framework, a bit of an understanding of what the difference is between a consumer and a non-consumer. I think if nothing else, we might understand a bit more of that and why that matters. So Stuart Kelly, my colleague and also former student, alumnum, I never get the Latin right for the singular of our program, um, is going to talk to us about this today. Stuart's pretty well qualified, both a mediator and a law teacher. Claims he's not qualified and there doesn't really teach consumer law. Sorry, not qualified, but he teaches many aspects of private law and has a background in litigation, not least for Scottish Power. Am I correct? Yeah. So there we are. They feature occasionally. So yeah, we might even get a conflict of interest out if you one day, Stuart. So I think he's very well qualified, and I think I will hand over to Stuart without further ado. We are recording this session, and I hope that's okay with everybody. Stuart, over to you.
Okay, thank you everyone. Thank you for the introduction, Charlie. A couple of just housekeeping matters. I'm sat in the university building tonight, so if I have to speak to someone in the background, it's because I'm in an open plan area. What will inevitably happen about 6:30 or before then is a security guard will come in and try and get me to leave the building. So if you hear me telling him to leave me alone, I'm not getting abducted or anything. Um, just another point is I'm really sorry about the light bouncing off my bald head. It's really quite disconcerting for me, and it must be for you. So, but to all of you who have hair, good luck, enjoy it. So I'm just going to share my screen now, and hopefully this will work. He says. So just give me 2 seconds while I do the inevitable playing around with this. Can I maybe get a thumbs up or a thumbs down or whatever if that's showing okay? Perfect. Okay, so what I want to do is to give a very brief overview to consumer protection law in Scotland or consumer rights, whatever you want to frame it, and to think about latterly and hopefully start a Q&A discussion briefly is about how as mediators we can play a role in that process. Having prepared these slides, I'm conscious that some of the content is quite detailed and quite, in some cases, quite complex. I do refer at some stages to the law. Shock horror, I'm sorry. But what I'm going to do as a task for myself in the coming months, I'll make it plural so I don't give a timescale to Pauline or Rosie, is perhaps prepare a kind of guide to consumer rights, if that's of any help to you. So it's a resource that can be taken away. So one thing as well, if any of you are very keen at the end, I've got a copy of this book. You might not read it, Consumer Law in Scotland. So available at all good retailers, but hopefully my note to you will help as well. Okay. So first of all, just for the obvious point and the importance of consumer protection in Scotland, I think that goes without saying for present purposes, but we're aware of the need to ensure that consumers have adequate protection both in law and in practice, I suppose, and what the framework for that is. And particularly vulnerable groups or people who are exposed to vulnerable or poor trading practices, the law and wider policy seeks to find a framework that should support them. I suppose there's a question whether the reality actually meets that, and that's why when we get cases in the mediation clinic, there's a particular point about us being able to direct these consumers appropriately. I should also make a point that I'll probably defer to our mediation clinic kind of clientele, so to speak, for want of a better description, as being consumers. I think in reality that is the people who tend to come to us rather than being traders, for example, albeit that might be something of dispute we can discuss. What I'm going to propose to discuss tonight is an overview to consumer protection law in Scotland, potential basis for remedies, and then last of all, the intersection and perhaps a kind of dispute, if you want to call it, between mediation and rights. So the legal framework for consumer protection is relatively complicated. It consists of a number of legislation. The first one, the Consumer Rights Act 2015, is a relevant infant. Prior to that, the Sale of Goods Act in 1979 was the primary legislation. We also have other and more bespoke legislations. For example, consumer contracts, information cancellation, additional charges regulations. And you may also have heard about the Unfair Contract Terms Act of 1977. I'll briefly touch on unfair contract terms later, but what I would say is, subject to the success or otherwise of CPD like this, it might be something we can explore as a distinct CPD at another opportunity. But what I want to perhaps come back to is the Consumer Rights Act 2015. This was a legislation that had a policy agenda driven to try and streamline and rationalise consumer legislation in the UK. It applies across the UK, so we can't claim it as a Scottish Parliament success. But nonetheless, it's there to try and give a consolidated and simplified process for consumers to seek remedy. So as your starting position, we would be looking as legal advisors, but not necessarily mediators, to Consumer Rights Act. The main consumer rights that are contained within the Act relate to kind of some key headlines. First of all, there's this terminology of the quality and fitness for purpose. We have this idea of satisfactory quality or not, goods and services matching descriptions, digital content rights, which are quite a niche area, which I will not explore this evening, but particularly perhaps as more and more organisations and companies deal in digital content, that might be something we explore. And then there's obviously embedded into the consumer rights legislation is this concept of remedies, which we would call statutory remedies because they're contained within statute. Before I come back to the Consumer Rights Act, though, I just want to highlight a couple of areas which I won't be covering tonight, but for the avoidance of doubt, they exist, and that we can perhaps again address them in separate forum. The first one is this concept of protection against unfair trading, and there is a prohibition in law of unfair commercial practices, forms of misleading actions and omissions, and aggressive commercial practices. Many of you may be aware of that, for example, in payday loans and associated type activity. I'm not going to go into that in detail tonight. Safe to say that that is something that gets people into debt often can be a reason why people end up in the Sheriff Court. So it may be something we want to explore at a later stage. There is also the wider concept of consumer contracts as a kind of niche form or niche content. Well, not so much niche, but specific content. There are certain requirements for consumer contracts, the right to cancel contracts. We're just thinking the summer holiday season's upon us, if you have a flight, for example, to go to a certain destination which is cancelled, if you book a package holiday, etc., there may be lots of consequences for you if those contracts were cancelled. So these are, again, something I'm not going to explore tonight in too much detail. Safe to say that there are quite specific protections and guarantees there. And last but not least, product safety. There are a variety of product safety regulations in the UK which impose responsibilities upon the manufacturers, importers and distributors. Sometimes the one organisation can enjoy all three of those status. Sometimes companies are specific to one or the other. And there is wider duties about reporting unsafe products. Again, this is kind of linked to consumer legislation and consumer protection generally, but for present purposes, I'm just drawing it to your attention, but we won't cover it in detail. In terms of the wider infrastructure for consumer law in Scotland, there are what we might call enforcement bodies. The first one, at quite a high level, is the Competition and Markets Authority, the CMA, whose job particularly looks at, for example, regulating wider practice. So they might undertake a wider review into a particular industry. And indeed, to give you an example, which Charlie alluded to in my own professional career, I was involved in the energy market or energy industry, and there was a high-profile CMA investigation into the practices of energy suppliers, which led in part to the government introducing a price cap. So there can be roles for enforcement bodies. There's trading standards where consumers can go and seek to raise disputes about that, and that is usually run by local authority. There are Citizens Advice Scotland, who are both an agency, as we know, to seek advice from, but they also can provide in their collective form almost a kind of sense of collective action, in the sense of trying to kind of broker wider issues. And again, going back to my professional life, Citizens Advice Scotland often played a role in lobbying for certain changes to improve the consumer dynamic. And Scottish Government and its agencies will obviously seek to enforce, as applicable, rules that are relevant to them in the Scottish framework. So how do we seek redress? Well, in a consumer dispute, there are a variety of stages we might look at. The first is what I'm going to badge as informal. And if I receive a product or a service which I'm unhappy with, I may just ask for that to be remedied myself. So that would be what I might refer to as a small c complaint, or if I take it more formally, a capital C complaint. That may lead to obvious remedies, for example, replacement or refund that's just done there and then on the spot. That could be, for example, if you're lucky enough to be able to go to a restaurant for an evening meal, you may be unhappy with what's provided to you, and you may seek to have some form of remedy there and there. The more formal redress is, for example, if you were to take a complaint or a dispute to the court. And in some ways, that's how mediators get involved, in particular the mediation clinic, because we take referrals from the court. So that will involve someone having had the want and the ability and the time to take a complaint of a consumer matter to the court, and then for the court to refer it to us. There is also alternative dispute resolution. Of course, mediation sits within that broad family, that broad church, but there are specific remedies for ADR, which I'll speak about later on, which are not necessarily solely mediation. And last but not least, there are consumer ombudsman processes. So you can go directly to an ombudsman to seek to have a consumer problem dealt with. And there are a variety of ombudsmen. Again, I'm just drawing upon career experience. There is an energy ombudsman where you can go to, for example, if you have a complaint against your energy supplier, or you've got a problem with it, and the ombudsman can seek to have redress and impose some form of penalty onto the supplier for failure to adhere to it. So there are a variety of spaces in which redress can be sought. And the reason I think it's important for us as mediators to think about this is perhaps in our wider discussions with parties who come to mediation processes, I think it's important that we give them the proper awareness of the dynamic of what the redress options are for them, because mediation may or may not be appropriate. And that might be something that Pauline and Rosie take on, or anyone who does onboarding, but it's just that awareness that the court necessarily is not, and thus mediation, if we're referred to, is not necessarily the sole remedy. Okay, so that's all the fun stuff. I'm going to move on to the legal stuff now, which is less fun, so my apologies. The Consumer Rights Act 2015, I'll try and be as brief as possible. Section 2, okay, defines what we mean by consumer, and it means an individual. I'm going to stop there. So it's an individual. So it's someone who comes to you purporting to use the Consumer Rights Act, does so as an individual, not as a small company or as some form of, in a sense of trading, but it's got to be, for example, an individual. And so that's kind of the genesis, the root of this legislation. And you see that are acting wholly or mainly outside their trade, business, craft, or profession, because the law has different frameworks for what they conceive to be inter-trade relations. The Consumer Rights Act is there generally to protect consumers in what we would, the ordinary sense of the word. And I'm jumped now to section 9, which in many ways is perhaps the main one to start with, which is goods are to be of satisfactory quality. And what does satisfactory quality mean? Well, every contract, the law tells us, every contract to supply goods is to be treated as including a term that the quality of goods is satisfactory. So therefore, regardless of what the contract is or says, there is an implied term through law that the goods have to be satisfactory. And then sometimes we don't have a formal contract to rely on in consumer. So for example, this afternoon, as a substitute for having yet another coffee, I've got a bottle of Lucozade because that's what you do when you have some form of caffeine addiction, I assume. So by buying the bottle of Lucozade, I went into the shop. We had a very, it wasn't deliberately uncourteous, but there was not much it said between myself and the teller that the checkout. But nonetheless, I have a contract for sale. I was a consumer in that purchase. I bought it from the shop. Thus, I have obligations and legal rights that come from that legal relationship. I didn't make a big deal of the fact that I was quite excited about having consumer rights, but nonetheless, they're there. And so regardless of how the fact that was an informal, that was a non-spoken, it was a verbal, an exchange of, I have exchanged money for goods. So the reason I'm saying that and why it's important is because some people get quite upset or agitated if they don't have a formal contract. And if they do have a formal contract, there might not be provision in it for how we deal with this issue about satisfactory. But nonetheless, the law imports it, it implies it. Section 2 goes on to define what do we mean by satisfactory goods, and it says the quality of goods is satisfactory if they meet the standard that a reasonable person would consider satisfactory. And for those of you who are familiar with the law or have had any unfortunate dealings with it, you may be aware that the law uses this term reasonable person. And that's effectively meant to be an objective test where the law can import what is reasonable in the circumstances. And what the law says we should take account of is a description of the goods, or any description if there was, the price or other consideration for the goods if relevant, and all other relevant circumstances. So just to pause there, any description of the goods may be how it is specified in advert, how it is specified in a written formal description, how it can be verified that it was sold. The price may also dictate if I'm going to spend, £1 on something, then perhaps I'm not expecting it to be a huge or of particular quality. If I'm going to spend £50,000 on a car, there'll be a difference. So the question about quality can often be assumed or implied via price. Moving on to section 9, subsection 3, because I know you're all enjoying this legal analysis so far. So the quality of goods includes their state and condition, and the following aspects, among others, are appropriate. And this is the kind of key test that the law imports. First of all, is the fitness for all the purposes for which the goods of that kind are usually supplied. So fitness. There's then appearance and finish, freedom from minor defects, safety, and durability. So under quality of goods, someone can expect if you or I purchase something that we're entitled that all of these things meet or the reasonable person's understanding of what that product, what that good should be in the circumstances. And there is some intersection between these items. So, fitness for purpose may also link to durability. If I buy a car, and there's plenty of case law about this, if I buy a car and after a month it breaks down, I might say, well, wait a minute, and that's not durable. It might also not be fit for purpose. So there's questions about where it goes in that circumstance. However, there are some exceptions because the law and statute loves creating exceptions to the rule. So satisfactory and quality does not, satisfactory does not apply or our goods are not unsatisfactory if a particular defect or issue was specifically drawn to the consumer's attention before the contract is made. So if I'm told that something's got a particular issue with it, I cannot then rely upon consumer protection legislation afterwards. Also, if a consumer examines the goods before the contract is made, so long as the examination ought to have revealed it. So, for example, if I go to buy a car and I do a visual inspection of the car, I cannot laterally claim for a visual defect, which I should have been able to see, but I may obviously not be able to inspect, for example, the nuances of the engine. So there can be discrepancies there about what is visible. And lastly, potentially, if goods are supplied by sample, what would have been apparent on a reasonable examination of the sample. So going back to the reference made earlier on, though, about the characteristics of the good, it's really important if you're looking to deal with a consumer case that we actually try and find out how the goods were described. Was there any advert? Was there any specifics? What were the expectations? Because obviously that would then become contractual rather than applied. And look at any public statement made in advertising or labelling if it's available. These are all useful to bring to attention. Okay, so that was section 9, and I'm sorry, I will get through the legislation shortly, right? I know it's been a long day, and I told you I needed some Lucozade. So, section 10 goes on to say that goods have to be fit for a particular purpose. So, this is quite an interesting one. Well, lawyers find these things interesting, normal people don't. But what is the particular purpose? And this is, for example, if I say, for example, to a particular trader that I'm buying a product because there's a particular rationale. I want to buy this car because I'm going to drive to Germany for the Euros. And I want a comfortable seat because I'm going to be driving for 4 days. Then there might be a particular condition in the contract, therefore, that the only reason I'm buying the car is because I want a comfortable seat. If when I then get it, I don't have a comfortable seat, the argument could be made, well, that I brought that to the trader's attention before the purchase was made. And this is maybe a tenuous example, but nonetheless, the point being is if you make a particular point known to the trader, and then it's assumed to be that that's a particular purpose rather than a generic comment about quality or satisfactory quality. So another thing just to bear in mind there is this idea of a credit broker. The law makes reference to this. People get quite excited about it, but I suppose the way to think about it is if in the situation where someone is effectively a middleman or a broker, and in some ways, of course, you may be aware that you can seek to have remedy against a supplier of credit to you. So you can go against, for example, the provider of your bank or MasterCard as the intermediary. So, but I won't go into the specifics. Right, I think I've got 2 more slides on, one more slide on the law. You'll be delighted, okay? I want to just briefly touch on now, and it is very brief, about services. What I've just talked to you there is about goods. So if I go to Sainsbury's and buy a Lucozade, that's a good. If I go to, or if I don't know, try to think of a particular service, if I go to let's think of something. If I instruct a cleaner to help clean the university or whatever it might be, then they're providing a service. So you need to think of the distinction in service. If I go to a builder to build an extension on the house, if I get someone to fix something, but what I'm buying is not the product, but I'm buying their time, buying their service. And in my experience in the clinic, I've had a few of these cases whereby the dispute is about the quality of service provided. And it tends to be, in my experience, where, for example, a builder or some form of tradesperson has provided or not provided a service, and there's a dispute about the quality thereof. So this is where the services side of consumer legislation comes into being. So section 49 effectively mirrors section 9, which says every contract to supply a service is to be treated as including a term. The trader must perform the service with reasonable care and skill. So that again is an implied term. It doesn't need to be found in a contract. It doesn't need to be found in some form of exchange. And again, subject to your views on how you've seen mediations or how your life is rolled out, if I'm going to instruct a joiner to fix something in the house, I tend not to, in my experience, engage in any form of written contract with them. They might come round, they give a quote, we agree it, and invariably, apparently, I get it wrong when they don't do what I thought they did. So, but you might then, if you're clever, follow up with a series of text messages or an exchange. But nonetheless, you would try and set out the boundaries. But regardless of whether you do that or not, there's an implied term about reasonable care and skill. It then goes on to say that section 51, as the section applies to a contract, to supply service if the consumer has not paid a price or a consideration for the service, and the contract does not does not expressly fix a price, then what under Section 51 we get is there's a right in legislation for the court to import a price. So there's a legal remedy there for them, and they can import what they call a reasonable price under a question of fact. So that's just a very quick overview to the kind of scaffolding and the infrastructure of consumer rights. And just to kind of quickly kind of follow up on it, we've got the distinction between goods and services. Goods is the purchase of a product. Service is the purchase effectively of a provision of a service. The question therefore is, what are we entitled to? Now, there are statutory remedies under the Consumer Rights Act. For goods, there is what we call a short time right to reject, which is within 30 days of purchase. There's some nuance on that. For example, if within the 30 days I identify an issue and I go back to the supplier or the tradesperson and ask them to, or trader, sorry, and ask them to fix it, then my 30 days is paused, and it's only when I get the product back that the remainder of my 30 days kicks back in again. I have an opportunity for repair and replacement, and I ultimately have the right to rejection. There are quite some details on this, but in some ways I'm not too bothered about that for present purposes for mediators. And the rationale for that is by the time we get mediated cases through the mediation clinic, many of these timescales have lapsed. You know, like if a consumer's getting nowhere with their supplier, you know, by the time they've actually raised a share of court action, gone to pursue it, the 30 days, the 60 days, whatever it is, are well gone. So we have to kind of just remember that in context. So these statutory remedies in many ways don't really apply in the mediation context. But what is interesting and something for you to bear in mind perhaps when you're speaking to or trying to perhaps expectations set in a mediation setting or context is who is the burden of proof on when it comes to consumer problems. And when pursuing remedies, the burden of proof, particularly in goods, if it's within 6 months, the burden of proof falls on the trader to prove that it wasn't faulty, if that makes sense, because it's assumed that within 6 months of purchase, an item should still remain fit for purpose. If it's after 6 months, it's the consumer's duty. So you need to remember, so that might be an interesting point for us when we're discussing that, because again, particularly who the parties are, we might want to explore who, if this goes back to court, who's going to have to prove the case, who's going to have to give that kind of level of expectation. And in my experiences in mediated cases, that's quite an interesting dynamic, because I think that sometimes changes the dial a wee bit. Briefly, just for this purposes, for services, what are the rights? The statutory rights are the right to require repeat performance and the right for a reduction in price. Again, it really depends on who your supplier is of services. A one-man band doing some sort of tradesperson work may not, they might simply tell you, well, I don't have time to give repeat performance. You know, if you want to get that flooring fixed, it's in 2 months' time, right? Or whatever the response is from a tradesperson. And the right for reduction of price, well, if any of you get a reduction in price from a tradesperson when you've had a dispute with them, that can sometimes be few and far between. So what tends to therefore, in my experience, be is that having given you all that boring infrastructure of the law, where we get to is actually the consumer rights legislation kind of falls away when it comes to sheriff court cases. And effectively what people are seeking is damages based upon breach of contract. Because although, and again open to discussion later on, in the cases I've seen that have come through the sheriff court, individuals or consumers don't often articulate it as such. They don't say what I'm seeking is X. But nonetheless, damages exist as a potential basis of claim. They sit outside the statutory remedies. Damages are effectively compensation. A court really, if it's acting properly, should be, it depends on the speed at which the consumer has raised the action, but a court should really be encouraging any consumer to exhaust their consumer rights and statutory rights through the legislation. So a case shouldn't be coming to the court for damages really until such stage as consumer rights legislation has been explored. And that could be, for example, with ADR providers, which I'll come on to shortly. However, just a reminder that there is time limits for raising court actions, and we call this prescription. So in Scotland, there's a 5-year period. So from the date of purchase or the date of the goods or the service being provided, you have 5 years to raise your action in court. In England, you get slightly more time. It's 6 years down there. But so up here in Scotland, it is only 5 years. And just to jump back, because I missed that bullet point, damages may include grounds of loss, which we can refer to in the law, such as financial loss deriving from the breach. For example, if you may argue, well, this defective service has cost me X because it's had a knock-on consequence on something. Or I've had to take a day off my work to deal with this problem. I want compensation. Or I have suffered personal injury because of your breach, then therefore I want compensation. So there can be, damages can be a more collective catch-all concept as to what remedy you may have. Which brings us on to consumer law and ADR. So there are regulations which derived out of the European Union, which were then imported into UK law. Who knows whether governments past, future, or whatever will introduce such further similar with keenness. But the Alternative Dispute Resolution for Consumer Disputes, Competent Authorities and Information Regulations rolls off the tongue. That was introduced to provide some sort of framework for complaints procedures and to give, particularly for larger organisations, the ability to comply with what we call ADR bodies. In particular trades and industries, whether it's, for example, if we think about maybe, I don't know, supermarkets, for example, or energy companies, there may be dedicated kind of national ADR provider of bodies that support the trade. And there may be that there's scope for consumers to be referred to specific ADR bodies. And again, that's a question really of contract. Something perhaps as a clinic, and forgive me to Pauline and Rosie if this is something we do already, but it's something that perhaps we could be thinking to advise certain people in certain disputes whether there's already a remedy. That said, if they've gone to the court, maybe the horse is bolted because they're coming to us. I should say that there is a distinction between large and versus small traders. A one-man band doing joinery work will likely not have an existing relationship with an alternative dispute resolution body for the trade, and may not subscribe, may not pay for the service. And thus, in many ways, despite the provision of it, you might have to go to court. Which brings me to the final slide, guys. So I did try and bring this into half an hour. When we then get a referral to mediation from the court, the key point I want to draw to your attention is that in many ways that suggests that the wider statutory framework for consumer rights has either been exhausted or just simply not used. And there's maybe a question point for us as mediators to be clear on that. Has there been any attempts to bring involved whether kind of ADR bodies, has been an attempt to use the right to reject formally or otherwise? These I don't think are critical for the court. I think when it comes to kind of simple procedure type actions in Scotland, I'm maybe being a bit optimistic or pessimistic, whatever the description right is, but I think the judges tend to be quite practical focused about trying to get a remedy. And I'm not sure the judge is going to get tripped up or trip the parties up over the nuances of the Consumer Rights Act, for good or for bad. So that is just something to bear in mind. But one of the consequences, and I think we touched on this, some of us at the start, just before everyone else dialed in, is that where I might see is the interaction, the intersection between rights-based remedy and mediation. And it's just something to bear in mind that to remind us that there is wider law, what we call wider common law, sorry, which is effectively law driven by the courts, not necessarily by statute, where there is this concept of damages. And there are associated rights to damages that come from consumer protection. And I think as mediators, it's something that we need to be careful about. For those who are inclined to criticise mediation, often they do so from the basis, that kind of Hazel Genn position, for those of you who've done the course, which is you're diluting people's rights. By mediators a mediation process shouldn't try and dilute what someone should get as a remedy if they went through the court process. So her criticisms, insofar as they're well founded, is that mediation should not be in that position, or consumers should not be in that position, or any party. So I think it's something for us to bear in mind that if we are speaking to a consumer, you might want to explore whether in pre-mediation or in private caucus during mediation or during the kind of joint mediation itself, how they explored their consumer remedies. Are they aware of their consumer remedies? Are they aware of their rights under the Consumer Rights Act? Have they undertaken any form of ADR through the relevant trade body? What have they done to try and exhaust that? And I think sometimes it may help the consumer, dare I say it, if the matter has to go back to court, to be able to verbalise and articulate that they have exhausted all those particular issues. So, one final or penultimate point just to bear in mind is that consumers are entitled to rights, but also not everything is a problem and not everything is a defect in law. Someone might be a bit annoyed about the services being received, or they might be a bit upset about a particular issue, but that doesn't necessarily mean it's defective, and it doesn't necessarily mean it meets the statutory criteria for satisfactory quality or for reasonable skill and care. So sometimes you have to disentangle poor customer service from poor service. And often, for example, in energy, when I was involved in that, a lot of the huge frustration of people coming was not necessarily about the service they provided, as in when an engineer came out to fix a meter in their house. That wasn't the problem. The problem was the fact they waited 45 minutes to speak to an operator on the phone. So there's just trying to disentangle what the actual issue is. And last but not least, just to pose it open to you guys, is that what is the role for the mediator here? And perhaps people might want to discuss that. Right, finally, before I finish, there are, if you don't want to read this brilliant book, look at how good it is, lots of consumer law in here. If you don't want to borrow it, feel free to let me know. There are some decent already existing guides, and I don't want to claim credit for them. The House of Commons Library has one which they provide to members of Parliament in the Consumer Rights Act 2015, a guidance note, which is only 20 pages and it's written in quite bold font. So I would maybe recommend, if any of you want to read that, that's a good guide to consumer rights legislation. And maybe a good aid memoir for you all, if any of you pick up a mediation where there is a kind of underlying consumer issue to it. These research briefings are quite useful to me because they're written to try and advise members of Parliament or their case surgery workers who often deal with these sort of disputes, when people might go to their MP or their MSP trying to resolve a problem. So if you can, I'd have a look at that. The other one, which I didn't print out because I didn't want to destroy the paper of university, is Citizens Advice have a great service as well on their online provision. So they set out both for England, Wales, Northern Ireland and Scotland, not for both, for all the different jurisdictions of the UK. They have a very clear framework for how consumer rights apply. So just something to bear in mind. Again, if you want to just reacquaint yourself with where to find it, I would recommend Citizens Advice, and I can send a link to this via Pauline and Rosie to the House of Commons briefing papers. I'm happy to as well draft something together if it's of any use to anyone. But just as a final recap before we move on, just to remind you, there is a distinction between goods and services. Goods have to be of satisfactory quality and fit for the particular purpose. Services have to have reasonable care and skill, and this idea that they can't, that people have an opportunity to seek some form of remedy. Now, I'm just going to pause there for any questions. I don't know if that's I did say I'd try and bring it in half an hour, and that's 35 minutes. I'm very sorry.
Thank you, Stuart. I'll open it to questions. I was going to ask you to stop sharing your screen. So yes, that sparked a number of thoughts in my own mind, but I'm interested to hear what it sparks in the minds of others.
Sorry, Charlie, it's Alison. I've got a bit of a sore throat, so no. Sometimes the party, usually the claimant will ask, well, always the claimant will ask about, do you know what my rights are? You know, they'll ask the mediator sometimes that question during the mediation. You know, or they'll say, I'm not sure what my rights are under, you know, and the consumer rights, and you know, sometimes you feel a bit bad that you can't kind of direct them to that. So I was thinking about, you know, the intake form, if we could maybe ask some of those questions, because I think it would be quite useful, you know, from a kind of responsibility point of view, to maybe ask them very early on, if they have spoken to anyone about their consumer rights.
That's an interesting question. Can I just share something with you from my thesis? I interviewed a particular consumer who had bought a sofa. And so I was speaking to this man, I think it was a chap, after his mediation, which had actually settled, but he wasn't very happy about it. But what was quite striking was that he had sought advice from two different sources. He'd spoken to a solicitor. He'd also been to Citizens Advice Bureau. He'd also been told by a sheriff in a case management discussion the same thing. All three of them told him that he would be unlikely to get the full value of the sofa after using it for 5 years. And he didn't agree with any of them. He thought the sheriff had just personally taken against him. And he said, I know under the Consumer Rights Act, you've got rights for 6 years. Now, as an interviewer, wasn't not my job to argue with him, but it was just an interesting glimpse of the the issue there, Alison. In a sense, I'm just saying that I'm not sure we can ever avoid in the moment as mediators dealing with what's in front of us, and there may well come a case for saying, "Have you spoken to someone else?" Or, you know, would you like to take advice? I'm not necessarily the person who can help you, but I've got some question marks about how much we can do to preempt people's state of knowledge.
I'm just wondering if we could ask that question up front. That's what I was thinking. You know, does that, you know, I think that's what I took from, you know, the presentation was, is there a place in these particular types of disputes to maybe ask the question up front, so that we've at least, you know, pointed them in direction, or suggested it.
What do others think?
Could I just add something? We've actually just had a conversation and we've revamped our intake forum for the clinic as well. Now, we've gone through that there's a list of organisations that we want to share with everybody that comes to the mediation clinic. So what we're going to do is, once it's published on the website, so it's a list of things like Shelter, Consumer Scotland, Citizens Advice, Scottish Association of Landlords, that kind of thing. And what we're going to do is, in the invitation email, is direct parties if they are needing we've not actually worked out the wording for it, but to say how the advice is available from these organisations. So it's going to both parties, and both parties will be aware of it. I don't know if that would help the situation, Alison.
Yeah, no, I think that would be useful. I think it's just, you know, whether we have any duty of care. Well, we don't have a duty of care, but kind of a moral obligation to at least give them the information that someone that can give them the information if it was useful to them. So I think that personally, I think that would be good.
Okay, thanks. I see Lorna's got her hand up, so I'm not closing that down, but I think that's opened up quite an interesting angle for us all. Lorna.
It was a similar point, actually. Just reflecting on those sort of sources of advice and other forms of remedy that were put up there. I had a case which wasn't successful, where one party had been to trading standards and got advice, and I think the other had sought advice from a solicitor before the mediation, and it completely entrenched their positions. And because they felt that this is what trading standards said, that was the law, then they weren't willing to move, and it made the mediation impossible because they weren't willing to think differently or look at other options that were outside of that. So it was quite a difficult tension between getting advice, understanding rights and obligations, but actually being able to move beyond that and have a sensible discussion about something that probably wasn't black and white. So yeah, I'm interested in how others might deal with that, but also in the understanding of bodies like trading standards of what mediation is, and whether they ever take that into account in their advice.
Thanks, Lorna. It's a very interesting observation, actually. Yeah, I'm familiar. Leon.
Yeah, thank you. I was just going to say that I had the exact opposite experience to what Lorna just described there. So I had parties that wouldn't, well, one of them had legal advice and was very comfortable with their position, and the other hadn't had any legal advice yet and refused to take anything any further until they got that advice. So we had to pause the mediation and send them to the law clinic, and then spent about 3 weeks to a month shuttling emails between the two to try and eventually accommodate a settlement, which they did then get to. But as I think Alison was saying, was that if we had some way of encouraging people to seek that beforehand, we could have saved, well, I could have saved myself 3 weeks of sending emails back and forth.
Possibly. I think I'm just problematizing that. But think about commercial mediations where the lawyers are in the mediation. So although they're giving advice beforehand, they are also adapting and adjusting their advice and positions in the light of what they're learning in the mediation. So I think there's really interesting distinction between what would you call it, decontextualized advice in advance, and then an advisor in the moment, which we probably can't afford all the time in simple procedure, but there's nuance there somewhere. Now, I saw someone else who looked like they were.
Charlie, you might remember, you might remember this, Charlie, and not just because of your experience, but I used to remember in the Sheriff Court 20 years ago, there was an in-court advisor, they called it, at certain Sheriff Courts, where I think the Citizens Advice or Legal Aid Board provided it, probably got cut. But it used to be someone that if you, in what was then small claims, if the sheriff was not persuaded that the party understood the legal issues, they could go and get almost on the spot legal advice. And I sometimes think maybe that might be the answer to some of that point, which is, could you just explain a very, very quick 5-minute plotted history about how consumer rights work, timescales, etc. Sometimes it's just that. But again, going back to your point, Alison, it's whether it's the ethical boundary when we're the mediator, that we can be the one that gives one party particular advice.
Thank you. I see Gordon.
Yes.
Yeah,
Sorry. I was just thinking that it's great to put these things into a form, but that presupposes the person you're dealing with is going to read the form, and there is I think in my experience, that reading forms is not something that people are very good at doing. If it could be done at pre-mediation by a specific question for the intake worker, it is something that's going to be specifically raised as a specific point with the party, and at least give that opportunity for that party to go and do something. But I think it'll have more impact if the intake worker is actually asking the question, have you thought of doing this? And it'd be worth looking into, etc. If it appears to be a relevant case. That way you wouldn't then run into, you would mitigate against the possibility of getting into the mediation itself and then finding yourself in a situation where there could be a consumer issue, and you're in it, whereupon you may feel you might have to abort the whole thing. Better to preempt it, I think. And I think the persuasive capacity of intake workers is good, to just make it easy for somebody to explore it in a pre-mediation manner, to either knock it on the head or, yeah, see it's a good idea.
Perhaps just naming it even already saying to someone, have you heard of the Consumer Rights Act? For some people, that will be novel.
Yeah, I think it's the personal aspect of it, I think, is huge. I say I would be very wary of assuming that people, I'm sorry to say this, necessarily read what we send them.
Thank you.
Newton's
Gordon McKinley, you got your hand up.
Thanks, Charlie. And Stuart, thank you for your presentation. That was really helpful. I'm really interested in this notion of what might go at the front end, and Pauline, what you're describing there, I think will be helpful, although what Gordon says is true. Folk don't read stuff. You know, I mean, anything that you put, you can be absolutely sure that a large proportion of folk will never read it. But Charlie, what you were saying there about that decontextualized thing, and this goes to a part of a conversation that a few of us were having this morning, and that is about the fact that as the mediator, you don't know what you don't know. And given that, being very cautious about what you do or don't say. As soon as we start talking about advice and advising parties, I'm getting anxious. Just about, you know, I'm not qualified to give advice, and I don't know whether you've told us half the story or a quarter of the story, or whether any of it is actually true or not. So just being really cautious about, yes, I think maybe the question, are you aware of your consumer rights, might be enough, but to go much beyond that, unless you're really concerned that somebody's being sold down the river and that you stop things and you suggest they go and get legal advice, which I have done as well. So a wee bit of a rambling concern there that we don't turn ourselves into adjudicators by accident.
Thanks, Gordon. I think a very timely reminder. Yes, I think I'm assuming that most of us would have a whole vocabulary of skills, if you like, in raising questions with people without being the source of that information. But if something's troubling you, on the other hand, if something's troubling you, I'm not sure that I would be comfortable if that remained completely suppressed and we were silent about it. That's quite a delicate balance to strike. Roy, you've got your hand up.
Well, a couple of things. Thank you, Stuart. I wanted to come back to you know, your potential for greater fame here, because I think we all sense that. But Charlie, I just wanted to go back to the remark you made about this person that was looking to have rights even within 6 years, and presumably this was an Englishman that was somehow trying to enforce those rights, because clearly those don't apply in Scotland.
It was a Scotsman trying to enforce them against an English company in a Scottish court.
Right. Okay. Thank you. And I'm wondering, Stuart, whether that fame could be some sort of capturing in video form, something we could make available on the clinic website, that essence of the House of Commons guidelines. I mean, that sounded like a handy place to get people to look at, and I'm wondering whether that would work, whether the Scottish government might be minded to fund that.
I'm not sure I can answer that last point. I think that's delighted if they did. I think it's a really interesting point, Roy. And I think one thing that I think maybe clients might benefit from is case studies as well. You know, like, and we can have lived experience of that in the mediation clinic. You know, where particular issues of we might know of cases now. We know factual matrix, but we don't necessarily. We then need to find the right law. I'd probably want to get that double checked by other people as well before I released it as being the right answer. But I think I'm very with you, Roy. Certainly the the House of Commons one is just there but I can happy to draft something up. And we could also think about something that could be more one for mediator friendly, and one more, maybe a resource that we would maybe direct then to members of the public if we were concerned. So there we go. Pauline, I've said it and we're recorded.
We'll play that back to you.
Could have just said nothing there. Yeah. Thank you, Roy, for that. I just maybe to go back as a final point, Charlie, the Citizens Advice website to me is actually brilliant. And I'm not sure if any of you have also used Shelter's website. Their Shelter do have a really, really strong legal advice resource, particularly for property disputes or like rent arrears or anything associated with it. And it's really a brilliant resource, and they're clearly very well staffed to do that. So if in doubt, I would defer to Citizens Advice website and or Shelter, because they are really quite strong in that space. And in some ways, there's no need for us to duplicate what other people are doing in the space for it already. But if there was more specific points we could draw out, then I think certainly we could try and complement that.
Thanks, Stuart. I just want a point for everybody, really. In our latest stats, Pauline, I don't know if this has changed. It varies slightly, but it's roughly, I think the last time it was 52% traders and 48% consumers. So in fact, but that's ideal in a sense, because consumers only have rights if they're in a contract with a trader. These are precisely the situations that the Act is intended to apply. But let's not forget that traders are also often, very limited in terms of their resources. They're not all Scottish Power. And a lot of them are, as you say, the kind of one individual who's doing a job. So we may also be a useful source of information. The trader may be completely ignorant about the rights that a consumer has. We should always remember, it's not goodies and baddies here. We could be a sort of source for quite a wide range of folk involved. Anyway, that's brilliant. Thanks so much, Stuart. Thanks everybody for your engagement, your interest. I think we should let this bed down. There've been a few ideas from this, maybe more to-dos for a number of people, probably including myself. So thanks everybody. We're actually on time, which I think we should just stick with. And I will say goodbye. A big, huge thank you to Stuart for your work on that. That was really systematic and helpful.
Okay, cheers guys, and see you all soon. Thank you, Charlie. Thanks, Pauline. Thanks, Rosie.